Hey, Paul here again, estate planning attorney, and in this video we're going to talk about whether your mortgage on your home must be paid in full if you transfer your home to a trust. Okay, so many people want to and do transfer their home to a trust during their lifetime, and they do it for one of any number of reasons. Maybe the reason people do it most is they want to keep the transfer of their home when they die out of probate. And probate is where attorneys and courts are involved in the sale or transfer of your home after you pass away. Second reason people want to transfer their home to a trust while they're alive is they want to keep their state's long-term care Medicaid program from having those estate recovery rights in the event you go into a nursing home, you qualify for long-term care Medicaid, Medicaid pays those nursing home expenses, then Medicaid has these estate recovery rights, or in other words, Medicaid has a lien on your home so that after you die, or if you're married, after you and your spouse die, Medicaid can exercise its estate recovery rights if you own your home when you die and force the sale of your home so that Medicaid can get reimbursed for what they spent on you in the nursing home. So that's the second reason people want to transfer their home to a trust to avoid those estate recovery rights. And then a little bit lesser but third reason some people want to transfer their home to a trust is for one reason or another they fear someone suing them, and they fear someone getting a judgment against them, and if they own their home in their name, they could lose their home. So some people want to transfer their home to a trust for liability protection or lawsuit protection purposes. But if you transfer your home to a trust and you have a mortgage on it at the time that you transfer your home to your trust, can your lender declare your loan kind of due and payable because you transferred title to your home without the lender's prior consent? So let me back up for a second. A due on sale clause in a loan stipulates that the full balance of the loan may be called due, or rather the loan must be repaid in full upon the sale or transfer of ownership of the property used to secure the loan. And under those circumstances, that lender has the right, but not the obligation, to call the note due in those circumstances. So let me give an example. If you own a home and you go and put your home for sale and you sell your home to a third-party buyer, then your loan has to be paid off upon the sale, and that new buyer must go out and get a new loan. So some people worry, and they ask me, they say, Paul, if we transfer our home to a trust, are we going to have to pay off, our entire mortgage before or at the time that we transfer our home to a trust? Or are we going to get some letter after we do it that says you owe your mortgage in full? And so that might require them to have to come up with $200,000, $300,000, whatever the mortgage balance might be. So any question to that question, any answer to that question must reference the Garn-St Germain Depository Institutions Act that was passed in Congress in 1982. Yes, that's 38 years ago. So that act provides that with respect to a mortgage on residential real estate, a lender may not exercise its option pursuant to a due on sale clause upon a transfer into an inter vivos trust in which the borrower is and remains a beneficiary of that trust, and which does not relate to a transfer of rights of occupancy in the property. Let's go back and take a look at that. So under the exemptions to the due on sale rights that a lender typically has, under the exemptions to those due on sale rights, it says that a lender can't exercise its due on sale clause rights if you make a transfer to what's called an inter vivos trust. Inter vivos means during lifetime. It's living trust and inter vivos trust is exactly the same thing. It's a trust you set up during your lifetime. So you're exempt from these due on sale clause rights that a lender has if you transfer your home to an inter vivos trust or a living trust in which the borrower, that's you, is and remains a beneficiary of the trust. And kind of in the typical avoid probate revocable living trust, yes, the person who transfers their home to the trust is a beneficiary of the trust, and which does not relate to a transfer of rights of occupancy in the property. So by transferring your home to your trust, you're not transferring the rights to occupy that house to somebody else. You're keeping those rights to occupy the house. So under those circumstances, the lender can't exercise its due on sale clause rights. You're good. Okay, couple of other noteworthy exemptions from the due on sale clause in the Garn-St Germain Act of 1982. In addition to the transfer of the trust that is exempt from the due on sale clause requirements, it also states that if you transfer your home to a relative resulting from the death of the borrower, so you pass away, you have a mortgage, you leave your home to a relative, or I suppose multiple relatives, then they can't exercise the due on sale clause then, so good there. And then also it says also exempt is if you transfer a home where the spouse or children of the borrower become an owner of the property. So husband has a house, he transfers some or all of it to his wife. That also the lender can't exercise its due on sale clause rights under those circumstances either. So the transfer of your home to the common and typical avoid probate revocable living trust is one of those transfers that is exempt from the due on sale clause in your loan. In fact, when you die, assuming you leave your home to relatives, that also would be another transfer exempt from the due on sale clause in your loan. So this is important stuff, important to know. It keeps people from staying up at night, keeps people from worrying. If you found it helpful, make sure you turn that gray like button into a blue like button. And then also make sure, if you haven't already, hit the subscribe button and the notification bell so you don't miss anything as I keep producing more relevant and pertinent estate planning videos that are based on experiences that I go through in my estate planning law practice, and I make videos pursuant to comments that are made to the previous videos that I've already made. Okay, y'all have a great day. We'll see you next time.